Good afternoon, everyone, and welcome to the American Constitution Society's annual Supreme Court review for the 2021-2022 term. My name is Christopher Wright Durocher, and I serve as Vice President of Policy and Program at ACS, the country's foremost progressive legal network with more than 200 student and lawyer chapters across the nation. ACS's mission is to shape legal debate, nurture the next generation of lawyers and judges, and ensure the law is a force to improve the lives of all people. If you aren't already, I'd encourage you to become a member of ACS. Go to acslaw.org where you can join and find more information about events like this one. Before we get started, a few housekeeping notes. 1.5 hours of California CLE credit is available for today's discussion. Additional information and CLE materials can be found on the event page on the ACS website and will be shared with all participants in a follow-up email. There will be time at the end of today's discussion for audience questions. To submit a question, please use the Q&A box at the bottom of the Zoom screen. Do not use the chat to ask your question, as we will not be monitoring it and your question will not be put in the queue. If you are a member of the press asking a question, please identify the outlet for which you are reporting at the top of your question. Now let's turn to today's discussion. Each year, as the Supreme Court term draws to a close and the summer begins, ACS hosts a discussion with academics, practitioners, and advocates about some of the most consequential and most talked about cases of the past term. In that sense, this year is no different. In just a minute, you'll hear from this year's distinguished panel, who will explain and provide context for some of the most watched and anticipated cases of the term. In other ways, this year is very different. It was the first full term that Justice Amy Coney Barrett served on the court, and therefore the first full term for the court's conservative supermajority. It was a term that second half was conducted across the street from where the confirmation battle took place for now Justice Ketanji Brown Jackson, the first Black woman nominated and confirmed to the US Supreme Court. It was a term conducted amidst growing calls for court reform that ranged from more stringent ethics rules to term limits for justices and adding seats to the courts. It was a term in which the full draft opinion of one of the most consequential decisions in the past half century was leaked to the public months before the decision was released, giving us advanced warning about how this court would handle the latest chapter in the fight over reproductive rights, and perhaps offering a glimpse into how this conservative supermajority might handle other cases looking to upend longstanding precedent. It was a term in which many court watchers have paid especially close attention to all of the 60+ cases the court has heard to get an idea of what these decisions say about the court today and where it might be headed tomorrow. To delve more into these cases and issues, it's my pleasure to introduce our moderator for today's discussion, Tom Goldstein. Tom is best known as one of the nation's most experienced Supreme Court practitioners. He has served as counsel to a party in roughly 150 merits cases at the court and recently argued his 45th. In addition to practicing law, Tom has taught Supreme Court litigation at Harvard Law School since 2004. He is also the co-founder and publisher of SCOTUSblog, a website devoted to comprehensive coverage of the court, which is the only webblog ever to receive the Peabody Award. Tom has received a variety of recognitions for his practice before the Supreme Court and for his appellate advocacy generally. In 2010, the National Law Journal named him one of the nation's 40 most influential lawyers of the decade. We are delighted and lucky to have him again as the moderator for this annual event. Welcome, Tom, and panelists.
Thanks so much, Christopher. And wow, a lot of people's worst concerns about what would happen in the Supreme Court term have come to pass. At the same time, this is a day of celebration for many because of Justice Jackson taking her seat on the court today. We have an incredibly accomplished panel of academics and practitioners who are specialists in the fields of the court's major decisions from the term, able to talk to us about what the court has held and what it means for later cases, later controversies that are sure to come up as follow-on decisions and new issues continue to come to the court and to this, as Christopher says, conservative supermajority. We're going to walk through the major decisions of the term, including, of course, with respect to abortion and with respect to gun rights, immigration, citizenship, environmental law, including major decisions that were just issued a couple of hours ago. And we'll try and put those in the context of what this court is doing and where it is going, the broader doctrinal rulings that it's making and its implications for any attempt at progressive legal developments, and related controversies, including, of course, the question of the leak of the opinion, why it happened, and what it will mean for the court going forward. We're going to start with reproductive rights, and we have an incredible specialist in the field. Caroline Corbin is at Miami Law School and formerly an attorney with the ACLU's Reproductive Rights Project. So maybe you can start us with those decisions.
Okay, so the first thing I want to say about dogs is that it is a devastating decision that will ruin lives. So even though I'm going to be conducting a more cold-blooded constitutional analysis, I'm well aware that losing the right against forced birth has truly dreadful real-world consequences. So here's what I'm going to do in my 10 minutes. First, I'll summarize the majority opinion and concurrences. Next, I'll consider the possible consequences for other fundamental rights. And finally, I'll offer some critiques. So we all know that Mississippi banned abortion at 15 weeks, which is way before viability. Previous Supreme Court decisions, including Roe v. Wade and Planned Parenthood versus Casey, not only established a right to abortion, but held that bans before viability violated that right. Dobbs overruled Roe and Casey to declare that the Constitution does not protect the right to abortion. According to the court, the Constitution only protects fundamental rights that are either explicitly listed in the Constitution or that are deeply rooted in our nation's history and traditions. The text of the Constitution does not mention abortion, and according to the court, the right to abortion is not deeply rooted in our nation's history or tradition. Nothing in state constitutions, state statute, judicial opinions, treatises, the history the court consulted, declared that women have a right to end a pregnancy. On the contrary, the court writes, most states have banned abortion at the time the 14th Amendment was adopted. And it is the 14th Amendment that provides protection for fundamental rights. So if the right didn't exist when the 14th Amendment was ratified, then the right does not exist today. But what about stare decisis, the principle that courts should follow precedent? The Supreme Court gave 5 reasons why overruling Roe is appropriate. Notably, these reasons do not match the list of reasons traditionally considered in deciding whether or not to follow precedent. In other words, in overruling precedent on abortion, the Supreme Court ignored precedent on stare decisis. So what are these reasons? Most significantly for the court, Roe was egregiously wrong the day it was decided. Just as Brown versus Board of Education was right to overrule the indefensible Plessy v. Ferguson, Dobbs is right to overrule the shameful Roe v. Wade. And one reason Roe is shameful is that it was an exercise of raw judicial power in making up a new right. Okay, I know I'm in the summary stage, but I just want to pause there because I have to underscore the chutzpah of complaining about the exercise of raw judicial power in Roe, given that Dobbs is the poster child for the exercise of raw judicial power. And to compare Roe to Plessy, Plessy is the case that constitutionalized segregation, the case that ensured Black Americans were second class. Roe obviously didn't do that, just the opposite. Roe helped women move away from second class citizenship. All right, back to the reasons why it was right for them to overrule it. Another reason was that the existing abortion doctrine was unworkable. And this is one of the factors that is often considered if courts can't actually apply precedent. It makes sense for it to be revised. But how the court applies it is just rubbish, like so much of the opinion. The rule that all pre-viability bans are unconstitutional, the rule that could easily have decided this case, that's about as simple a rule as you're ever going to find in constitutional law. All right, to summarize the majority opinion, which is the controlling opinion because it has 5 votes, the right to abortion is not deeply rooted in our nation's history and tradition. And to conclude otherwise is so egregious, we have to overrule the cases that recognized a right to abortion. Justice Kavanaugh's concurrence adds nothing but a fake claim of neutrality. He argues that the court is simply being neutral with regard to abortion. True, the majority holds the Constitution doesn't protect it, but it didn't hold that the Constitution prohibits it either. So we should be thankful for this neutrality. Chief Justice Roberts, who would prefer to eliminate women's rights incrementally, laments the fact that the court did not simply uphold Mississippi's law without completely eradicating the right to abortion. Justice Thomas would burn it all down. As far as Justice Thomas is concerned, substantive due process is an oxymoron. He would eliminate all fundamental rights that depend on it, including the right to contraception, the right to sexual intimacy, the right to same-sex marriage, though he does not mention the right to mixed-race marriages. Notably, the court doesn't need to adopt Thomas's approach to eliminate other fundamental rights. The majority's new test is enough to put them at risk. Remember, if the right is not deeply rooted in the Supreme Court's version of history, then it's not protected by the Constitution. And I think we can all be fairly confident the Supreme Court can readily construct a history where neither contraception, nor sexual intimacy, nor same-sex marriage is deeply rooted. All right. There are obviously law reviews worth of criticisms, but let me highlight 3. First, it is ludicrous to make 19th century history the touchstone for our fundamental rights today. As the dissent pointed out, this approach means that women in the 21st century do not have a right to abortion because the same white men in the 19th century that did not let women vote also did not declare that women had a right to abortion. That is no way to do fundamental rights. We should not be relying on a history filled with racism and sexism and homophobia to determine our fundamental rights today. Second, even if history were dispositive, the court's conclusion that abortion was not deeply rooted is contestable. And this is setting aside all the issues with the Supreme Court's version of history. Even if the court were to look at history, it framed the right in the most narrow way possible. So for example, when the Supreme Court was deciding whether marriage equality was protected by the Constitution, it didn't ask whether same-sex marriage was deeply rooted in our nation's history or tradition. It asked whether marriage was deeply rooted. Here, the court did not have to ask whether abortion was deeply rooted. It could have asked, is the right to bodily autonomy deeply rooted? Or the right to control your own medical treatment? Or the right to make decisions about procreation or your family? Or as the dissent put it, the right to own your own body. Dobbs' majority intentionally did not. In other words, the fix was in from the start. And third, one of the majority's leitmotifs is that abortion is different from any other right because abortion is murder. Okay, it didn't use such blunt language, but that's the gist. It's a major reason why Roe was so much more egregious than other substantive due process decisions. But of course, this idea that a fertilized egg is a person from the moment of conception who deserves the same consideration as an actual woman is ultimately a religious point of view and not a universal one at that. In the US, it's the view of a powerful subset of Christianity. Other religions don't share that view. In fact, one synagogue is actually challenging an abortion ban on the grounds that abortion is often religiously required. So what's my final point? My final point is that the Supreme Court is imposing one religious viewpoint onto all of us. Or, to put in a way for you common law geeks, just as Lochner read into the Constitution one particular view of economics, the Dobbs Court has read into the Constitution one particular religious view of pregnancy. So there's tons more to be said about equality, geduldig, legitimacy, callousness, but I'm on a strict time limit, so I'll stop there.
Thanks so much, Caroline. Sorry, thanks so much, Caroline. And very impressed that you're able to stick to the timeline in such a momentous decision. Let me just pause and see if anybody else from the panel wants to raise an issue or ask a question. I'm particularly interested in what the next generation of controversies is going to be, both with respect to reproductive rights and substantive due process and privacy more generally. You know, where do they go next? If there is, you know, functionally a 6-justice majority and it's just the Chief Justice who's holding back on the question of timing, not the outcome, where does a supermajority that really is convinced that prior doctrine was grossly wrongly decided and that the Constitution has nothing protective to say about any of this, what comes next? Caroline or anybody?
Oh, well, as I said, what comes next is the elimination of any other right that they feel hostile towards. Because again, the new test for determining whether there's a substantive due process right is whether it's deeply rooted in our nation's history and tradition. And I think that leaves many of the rights we now enjoy vulnerable. Certainly, I think the right to contraception could very well be in its sights next, because again, they can look to history, cherry pick what they want to see, and conclude that this was not a right that was recognized by the men who made the laws and wrote the treatises and decided court cases, and therefore it's not protected by the Constitution.
And what about with respect to reproductive rights specifically? What are we looking at? Are we looking at, you know, different forms of contraception that conservatives view as abortifacients? Like what fights next?
So I think if you're setting aside like what else is going to get restricted. So here's how I think it's going to unfold. So first, they have already eliminated abortions for unwanted pregnancies. The next thing to go will be abortions, even if they're medically necessary, because doctors will err on the side of caution. They're worried about losing their license, and they don't know if some judge is going to second guess their decision about whether abortion is necessary. The next thing that'll be attacked will be contraception, because it'll be deemed completely inaccurately abortifacient. So Plan B will no longer become available. Next will be medicines that might cause miscarriages, because again, doctors are worried. They don't want to be accused of inducing an abortion, and so they will err on the side of caution and stop prescribing that. Also, if life truly begins at abortion, medical research might be in trouble, IVF might be in trouble, right? And the states will also be coming after the women, especially if they can't target the providers anymore, as might be the case if medication abortion becomes more widespread. They're going to start imposing criminal penalties on women as well as abortion providers, because it may be the women are the only ones they can get their hands on. Then states will try and prevent women from going to other states to get abortion. We already see states drafting laws to try and do that. Next, miscarriages will be investigated as abortions. Miscarriages are insanely common. Everybody knows someone who has a miscarriage. Just ask the women in your lives. But because you can't necessarily tell the difference between a miscarriage or an abortion, and indeed the term for miscarriage is spontaneous abortion, now anytime a woman seeks medical care for her miscarriage, she may be investigated as possibly violating the law and inducing an abortion. Again, women's behavior during pregnancy will be monitored. After all, we've already established the precedent that the fetus has more rights than the women. And lest you think I'm just being hysterical, like all these things have already happened or in the works, right? It's a dystopian nightmare come true. And I haven't even gotten to the idea that embryos are people, and who knows what might flow from that. So you asked me what might unfold next in terms of women's access to control their bodies. I think those are some of the things that come next.
And what do you think can be done if the Constitution doesn't provide any of this protection? Do you think there's a realistic prospect of federal legislation, the president saying that he would support ending the filibuster with respect to making Roe v. Law a federal statutory right, state constitutional rights? Where are there just going to be battles everywhere? Is this going to be a ground war that goes on for decades?
Yes, it will, because there are so many questions that have been raised by this. Everything from, can you stop someone from traveling to another state? Can you, the free speech implications? Can you talk about abortion in a state that doesn't allow it? Can you advertise for abortion in another state? So will there be endless litigation? Yes, there will be endless litigation. Like, even the question is, what counts as medically necessary? What can be done? People keep asking me this, and I possibly will have a federal law. Maybe the federal government will establish clinics on federal property. Perhaps it will make medication abortion, the abortion pill, easier to obtain. I don't know. I really don't know what the odds are of that happening. The next focus is what happens in the states. It's all about what the states do or do not allow. We already know that half of them are poised to eliminate the right to abortion. Although there are some states that have affirmatively gone out of their way to protect abortion. And there are some states, like Florida, for example, that actually has constitutional protection for abortion in their own state constitution. And so there'll be litigation in Florida about what happens there when the Republican-controlled legislature tries to take away a right that a more liberal judiciary had held was protected by the Florida Constitution's explicit right to privacy.
Actually, Darrell, do you want to raise this question of state constitutional protections and litigation?
Yeah, because I think that the point is well taken. This says nothing to the excellent presentation about the problems about the protection not being nationwide and what the legislative fixes is. But one thing that seems apparent to me is that what we might see is a whole new round of sort of abortion rights politics playing out in state judicial races. Why? Because state judicial races in most states are statewide races. So you can't gerrymander, an outcome with respect to the elected judiciary in some of these states in a way that the state legislature might be gerrymandered to insulate it from unpopular abortion restricting kind of legislation, as we've seen already. So I'm kind of wondering what you think the future is when we talk about state constitutional rights to abortion, which, as people on the panel know, would not be subject to federal judicial review, right? The state Supreme Court is the last word on what the state constitution rights guarantee.
Caroline?
Again, I think it will be, the battles will be fought at the state level for what is allowed or not allowed in the state. I don't know how that will shake out. We'll get a better sense as time goes on.
All right, Darrell, why don't we stick with you? So Darrell Miller is at Duke, and among his many specialties is the Second Amendment. And obviously this term we have an absolutely momentous Second Amendment decision, which takes us beyond just the threshold question of whether there is an individual right untethered from a militia in the Second Amendment, and the follow-on question of whether that is incorporated against the states. Now the rubber hits the road, and we have a majority of the Supreme Court willing to take up gun rights cases and put meat on the bones of the question of what it means. So Darrell, can you take us through that?
Sure, absolutely. And thank you very much for the opportunity to speak to you today. So the case that I'm going to talk about is called New York State Rifle and Pistol Association versus Bruin, or NYSERPA versus Bruin. It was billed as the sort of blockbuster Second Amendment case of the last decade, and there's no doubt that it delivered. The gun rights forces put all their chips on this case, and they came up with a trifecta. So what did they want? They wanted the Supreme Court to say that the Second Amendment right to bear arms extends beyond the home. It did. They wanted the Supreme Court to say that the licensing rules that require some showing of proper cause or may issue, sometimes known as may issue laws, requiring proper cause or good cause to obtain a license to carry a gun in public was unconstitutional. The court said that as well. And then the big issue that I think that most people that were sort of casually watching it, but which I was deeply interested in, and in fact wrote an amicus or filed an amicus on behalf of neither party, was this methodological issue. The gun rights people wanted the court to say that that the method of figuring out whether some kind of regulation violates the Second Amendment or not is by a text, history, and tradition only approach. And they got that too. So they really did hit the jackpot with this supermajority of this court on these issues that have been close to the heart of gun rights advocates for the past 20 years. All right, so just briefly, before I sort of recap the case, what does this mean? Well, in a narrow way, I think it means that some of these states that have these may issue rules will have to go back and revise them. The court was fairly clear that the states that have what are known as shall issue, where there's more objective metrics for issuing licenses, that's constitutional. And so I think the states that have may issue licenses, like New York, California, New Jersey, so forth, will go back and revise their laws. The big issue is this text, history, and tradition only approach, because why it's such a big issue is because it affects not just this narrow issue about licensing, it affects how the courts are supposed to approach every regulation. Whether we're talking about regulations on the hands of guns in the hands of 18-year-olds, whether we're talking about regulations on large capacity magazines or AR-15s, whether we're talking about the so-called sensitive places doctrine, where schools and government buildings can presumably bar guns from the property. All these things are now up for grabs, that the court has endorsed this text, history, and tradition only approach. And there's no way, other way to say it. We're in a brand new world with respect to the Second Amendment and its effect on our lives. So let me recap the case very briefly. NYSERPA Bruin versus Bruin involved a challenge by two plaintiffs to the New York licensing law. This licensing law had, by the way, been in place for over 100 years. Its antecedent was something known as the Sullivan Law. And this required to have an unrestricted license to carry a gun in the state of New York. you had to submit an application to the licensing authority, which was either the local law enforcement official or a judge, and show proper cause. Now, what was proper cause? Well, according to New York, proper cause was some kind of need that's different than just the general need to have a gun for self-defense that's shared by everybody. So you carry a lot of money, you have credible threats against your life, you're a government official, like a judge that might be in peril because of the nature of your job. That was the kind of proper cause that this licensing law required. This was challenged, as I said, as a violation of the Second Amendment. And a six-justice conservative supermajority delivered for the plaintiffs and for gun rights advocates. The first thing that Thomas wrote, Justice Clarence Thomas wrote for the majority, he said that bear means just to carry, and that means to be able to carry the gun outside the home. He said that history is the metric by which you decide whether you can carry guns or not. And he says that the history showed a fairly robust tradition of allowing people to carry guns outside their home for purposes of self-defense, and that there was no unequivocal tradition that limited that to a good cause showing. He also rejected what was the predominant form of review of Second Amendment cases that ever since the Supreme Court's big decision essentially holding that there's an individual right to keep and bear arms for purposes like self-defense in Heller, that's 2008, rejected the kind of approach that the lower courts had developed for over a decade. And that approach was a two-step framework. The first step of this framework was a categorical or historical approach, where the court would look at categories or history and try to make a determination about whether the kind of issue that the party had brought up even raised a Second Amendment claim at all. So a person saying, I want to be able to keep this, shoulder-fired missile, for example, that doesn't present a Second Amendment question at all. It's just sort of categorically outside the Second Amendment. Why? Because there are longstanding regulations on dangerous and unusual weapons, and having a shoulder-fired missile is obviously a dangerous and unusual weapon. The second prong of this two-part framework in the lower courts was what we might think of as a conventional tailoring or scrutiny analysis. This allowed governments to proffer some kind of information or evidence about why they are regulating, what legitimate purpose they are trying to achieve through the regulation, and how much it actually impacts otherwise constitutionally protected activity. And this tended to arise in the conventional strict scrutiny, intermediate scrutiny context that's familiar in so many other areas of constitutional law. Justice Thomas, writing for the majority says this is one step too many, and that only the text, history, and tradition approach is the way to figure out whether something is a Second Amendment violation or not. Now, he was quick to add, in the opinion, that clearly we live in a different era than in 1791 when the Second Amendment was ratified. And what he assumed is that lower courts will take modern regulations from the 21st century or the 20th century and look at them and see if they are in some sense analogous to a historical regulation. He says you don't need an exact twin, but you have to have some kind of analog, and that determines whether or not the regulation is constitutional. Justice Alito wrote a concurrence, mostly taking on Justice Breyer's dissent, but he stipulated that the only issue that's being decided in the case was about the licensing rules, that nothing about who can possess guns or who can buy guns or the kinds of weapons that are available was being decided that day. Justice Kavanaugh, with Chief Justice Roberts, also reiterated that the holding was limited to this question about licensing. This is just about may issue versus shall issue, and the discretion versus lack of discretion of issuing these licenses. and reiterated that the right was not absolute, and even cited prior Supreme Court decisions in Heller and in McDonald versus City of Chicago, which is the incorporation case where the Second Amendment applies to the states, that properly interpreted, there would be a variety of gun regulations available, and that nothing in the opinion should cast doubt on longstanding prohibitions of guns in the hands of felons or the mentally ill, or taking guns into sensitive places like schools and government buildings, or on the commercial sale of arms. And even, again, quoting a prior decision says, these are just examples, there might be many others. Barrett wrote a concurrence kind of questioning what is the length of time to determine what the history is. And Justice Breyer wrote a dissent which essentially said, look at the real costs of gun violence in America. You are shackling legislators and the people's representatives in being able to address it with this hidebound history-only approach that A, is a rejection of what was settled precedent in the lower courts, and two, is a type of approach that judges just are really not equipped to handle. They might not know what the historical materials they're looking at actually say or mean. And it's incredibly judge empowering to do this all by analogy, which just depends on levels of generality. So it's a new world. What do I predict for the future? And I'll sum up really quickly. Certainly, I think that the future is about figuring out, what kind of regulations can survive this kind of text history and tradition only approach. I think a lot of what we had assumed about data on gun violence or criminological data now is going to have to be repackaged and explained to courts about how it relates to this analogical work that the courts are supposed to employ. So dangerousness, for example, having to do something with a historical regulation. And I certainly think that issues like training and this issue about where guns can be prohibited because they are sensitive will be the new front of both litigation and legislation in the future.
Thanks so much, Darrell. Does anybody on the panel want to raise something before we?
I'd be curious to talk about you mentioned, Darrell, the Justice Kavanaugh's concurrence, which I thought was really interesting because he and the Chief Justice have this concurrence. They join the majority opinion, but then it's really hard to reconcile what the concurrence is saying with the majority opinion. The concurrence seems to limit the rationale for striking down this New York law to the standardless discretion in the New York regime. And then, as you mentioned, it has this long block quote from the Heller opinion that lists the kind of regulations that were considered presumptively lawful, whatever that means. And some of those regulations don't seem to have nearly the kind of historical pedigree that this New York statute had. And so, if the New York statute couldn't cut it, how do things like, prohibitions on the mentally ill or sensitive places or the kinds of laws that are described here, like schools and government buildings, how do those get upheld? And so, just, wondering how you see the litigation playing out on this. I suppose these two justices did join the majority opinion, but they also seem to be sending a strong signal to lower courts that a lot of these kinds of regulations should be upheld.
Right. So, it's an excellent question. And so I can imagine a couple of directions. One might be that regulators who are trying to defend laws essentially say that the five justice majority, or six justice majority for the court really is, you have to incorporate, these caveats from Alito and from Kavanaugh and from the Chief Justice. Now, the most aggressive version of that would be to say something like the methodology, the text history and tradition approach was only deployed as to the specific issue about licensing, that that we should take heart in the fact that, you know, all these other regulations may be subject to more conventional present evidence about their effectiveness, and that's what we're doing. I mean, that's an aggressive way of reading it, but it's a plausible way of reading it. A more likely outcome is that I imagine Justice Alito and certainly Justice Kavanaugh and the Chief might be actually, you know, thinking about levels of generality. They might be imagining a world in which there's plenty of room for regulation because the levels of generality are so high. So, you know, there are tons of regulations in history, some with actually noxious, you know, pedigrees that are about disarming or keeping guns out of the hands of quote unquote dangerous people. And if it's at that level of generality, that is, these are historical regulations keeping the guns out of the hands of dangerous people, then a regulation on keeping guns out of the hands of persons that are in a mental health crisis or the mentally ill is just part of dangerous people. But this is one of the things that my colleague Joseph Blocher, who also writes on the Second Amendment, and I are really concerned about, which is the motivations, the justifications for these is going to be completely obscured below this weird kind of analogical dance that we're going to do, as opposed to this is the reason, right? It's the, you know, the reason why we're doing it is because of its effectiveness, and it has this effect on people carrying guns, which was much more transparent when the two-part framework was still in place.
Thanks so much. I mean, my one confident prediction is that the Supreme Court will uphold restrictions on bringing guns into the Supreme Court, just as it upheld the, you know, vaccine and mask requirements for coming into the Supreme Court, even if those didn't fly in a lot of other contexts.
What will be,
sorry.
Yeah, what will be really interesting is, again, you know, in a world in which sensitive places becomes important, how can, I wonder if sensitive places will float, right? It's one thing to like have people, you know, on the doorstep of the, you know, of the Supreme Court building with the AR-15s protesting. It's quite another to have them outside your home, you know, in front of your house with AR-15s protesting. That's, you know, and so this sort of floating idea of sensitive places is going to be an interesting dynamic.
Thanks so much. Let's turn to Edilberto Roman, who's a professor at FIU Law, and expert on citizenship law, immigration, territorial related issues. And we had not just a major immigration decision today, but also major ruling with respect to the rights of indigenous peoples and people in territory. So Edilberto?
Thanks, Tom. I appreciate it. It's wonderful to be here. I have to say how much I appreciate the previous two presentations. Unlike those, I don't have one case to review. And in those instances, in those two cases, we're looking at scenarios in which we're likely going to be discussing those cases for months on end, if not years, if not decades. I'm examining 5 cases that all, while not capturing the media attention, although today we did see a lot of discussion concerning the Biden v. Texas case, concerning the policy of remain in Mexico that I'll touch upon briefly. But the point I want to make is that these cases are somewhat of a harbinger of things to come in light of this court. And Tom, I think you raised the question of what we're likely to see in the future with respect to the Dobbs decision. And I thought the presentation related to that was fantastic. I would just add, I think not only did Justice Thomas provide us an agenda or a syllabus for future issues and attack, but just the next term, I think under the court's framework in Dobbs, we're going to see the end of affirmative action as the first salvo, so to speak, in the new philosophy, with either a textualist standpoint or the notion of a right being ingrained historically. at the time of the framers. And as you might suspect, that is a position that causes me great pause, given the somewhat sacrosanct view of the Constitution that the court seems to have, notwithstanding the excellent points that Caroline raised with respect to the nature of the Constitution and its limiting view of so many of us within the society. But getting to the issue at hand with respect to these 5 cases, there are a host of ways to examining them. We can look at them from a standpoint of separation of powers. We can look at them from a standpoint of the Administrative Procedure Act. We can look, at least 4 of them, we can look at them in terms of administrative law. In terms of those standpoints, it'll be hard to reconcile these cases. The way we can reconcile at least the immigration cases is to look at it in a general philosophical standpoint in terms of judicial philosophy of deference to the executive. And I think that's the best way to examining these cases, and it's consistent with a somewhat conservative view of the role of the court and versus the role of the executive. And that's would be the best way to examining these cases. But I'm going to take even a slightly broader look at these cases to incorporate the territorial case in terms of these issues. And I'm going to examine it in light of how famed historian Eric Foner examined these sorts of issues in terms of deciding who are the we and we the people in our Constitution. And that's how I like to examine immigration cases and territorial cases, to look at them as membership cases and how we decide them. So let's examine these cases briefly, again, because there are 5 of them. I won't go into great detail with respect to the facts, but I'll examine them fairly briefly and try to reconcile them and perhaps raise a couple of questions concerning them. I note for example, in the Q&A, the very first question raised, how do you view these decisions to affect future administrative law related determinations? And I'm happy to address that in the Q&A afterwards. It's going to be challenging because I think I had an answer to that up until this morning's decision, but we'll examine that shortly. So the first case I want to mention ever so briefly is Garland v. Gonzalez, and basically examined the question of whether the government can essentially detain immigrants for months or even years during immigration proceedings without providing them due process of a bond hearing. And this case does away with any view that pro-immigrant advocates have raised in recent past as a possibility of procedural or substantive due process coming into play or being a vehicle to provide rights for immigrants. In the Garland decision, the Gonzalez decision, the court by a 6-3 margin held that the INA, the Immigration and Nationality Act, bars federal courts from hearing detained immigrants' requests for class-wide injunctive relief. And the court went to great pains to come to that conclusion because, frankly, the language of the INA could be reasonably read to allow such challenges. And so much so that the court, in a somewhat ironic twist, said that these class-wide claims aren't available, yet individual claims are available. I think, again, a deference point to the executive and their stance with respect, the agency stance with respect to that, but from a statutory interpretation, from arguably even a plain meaning interpretation of the INA, very specific reference to section 1252F subsection 1, but we won't go into that level of detail given that I have so many cases, but I'm happy to discuss it a little bit further in the Q&A if the question arises. And then we go to the next case, Johnson versus Martinez. And basically, in this case, we're looking at a question raised that after being detained for several months, the petitioner filed for a writ of habeas corpus to the district court, challenging on both statutory and constitutional ground his continued detention, once again, without a bond hearing. Implicit in this is this question of due process rights. Does the Constitution provide some basic rights? And here the court once again came to the conclusion, again, with respect to deference to the agency, that the INA does not require the government to provide non-citizens detained for 6 months or even more with a bond hearing, notwithstanding the language of the statute that suggests that that states, frankly, that these matters have to be addressed within this time frame. But the court basically provided wiggle room, inconsistent with a strict reading of the statute. Now we move on to yet another case dealing with deference, again, to the executive in the immigration context. And in this one, it's Patel versus Garland. And in that case, we would basically look at a question of the court's ability or jurisdiction, like the two other cases examined, the court's jurisdiction to review a claim that in this context, in the Garland context, this is a scenario where an individual basically made a misrepresentation with respect to a driver's license application, and by virtue of that became disqualified from subsequently applying for citizenship. The petitioner challenged that administrative determination, arguing that basically it was a discretionary determination and the courts should look at the entire facts with respect to that argument. As you might suspect, the federal court here, much like in the prior two cases, concluded that federal courts lack jurisdiction to review facts found as part of discretionary relief proceedings under the INA. So the three cases are entirely consistent with respect to deference, with respect to arguably an almost overreaching to support the administrative decision and limiting the rights of the courts. Now we get to today's decision that many of us just heard about in the news a couple of hours ago. In truth, it's a decision I have to study quite a bit. I read up about it, but I have not completed my analysis of it, in part because it seems somewhat inconsistent. The only way I can find consistency with this case is, once again, the deference to the executive. In Biden versus Texas, the Supreme Court addressed the Biden administration's attempt to rescind the migrant protection protocols, better known as the Remain in Mexico policy. The Supreme Court this morning ruled that the Biden administration, on basically what was viewed by most to be a controversial immigration policy, had the authority to reverse the Trump era policy that requires asylum seekers to remain in Mexico while their cases are reviewed in the courts. Now, this case, while consistent with respect to deference to the executive, causes me some pause, and I'll have to examine it closely, because this reversal of a rule set forth by a prior administration seems to run in the face of the Administrative Procedure Act that normally would require a notice and comment period opportunity, as well as full administrative procedure rules associated with creating this new rule in terms of revoking the prior rule. Again, this is a matter that I'll be happy to address further in the future, and I know some media is here and happy to examine it. But other than looking at the issue of deference, this decision that was hailed by immigrant advocates as a windfall in terms of the opportunity to change a harsh policy in the past, is at the very least questionable with respect to the Administrative Procedure Act. The only way I would be able to reconcile it is to look at the prior decision, the protocols to remain in Mexico, Rico as not a rule, but as a policy. And then it would withstand some at least APA muster. Now I'm going to switch gears a little bit, still being in the framework of who are the we and we the people, and look at a decision that, while not capturing the headlines, individuals like myself, being Puerto Rican, as well as the close to 4 million others in the territory, as well as the over 2 million in the states, affects them directly. And that's the U.S. versus Valero Madero case, and where the court essentially, the way to sum it up, and I have basically 1 minute to go, said that Congress has broad oversight over the U.S. territories under the territorial clause of the Constitution, and by virtue of that, procedures such or rights such as the due process clause of the Fifth Amendment do not apply to the citizens of Puerto Rico, and in essence, they can be discriminated against under the Social Security Supplemental Security Income Program, notwithstanding the fact that there are U.S. citizens. And ironically, here we have a rift between Kavanaugh and Gorsuch. To put it bluntly, Kavanaugh used the stated or long-lasting language of, frankly, the racist decisions of the insular cases around the 1900s, and Justice Gorsuch was not having any of it, and basically attacked Kavanaugh's sophistry and called for the overturning of the insular cases because of the unequal treatment of U.S. citizens in the territory. And I'll sum it up by Justice Gorsuch's apt observation of the flaws of the insular cases are as fundamental as they are shameful. So we have, in essence, a set of decisions that gave us a very narrow view of who are the we in the Constitution, with great deference to the executive.
Thanks so much. Let's now turn to the environment and potentially a couple of other very significant decisions depending on time. Kirti Datla is the Director of Strategic Litigation for Earthjustice. And today we got a major ruling with respect to climate change.
Thanks, Tom. Yeah, so I think this presentation will echo two themes of the earlier presenters. One is that this is a case where the method of how the court decided the case is quite important, along with the bottom line kind of impacts that it'll have for climate. And the other is that this decision came out 4 hours ago, and more digesting will certainly need to happen before anyone completely wraps their arms around it, but I will do my best. So I think with this case, it has a complicated procedural history, but knowing at least a little bit of it is helpful to understand the case. And so just very briefly, the case is West Virginia versus EPA, and the case is about EPA's authority under one specific provision of the Clean Air Act, which is Section 111D of the Clean Air Act. And that's a provision that applies when two other major programs of the Clean Air Act aren't being used to regulate a specific kind of pollutant from a specific kind of source. So in 2015, the EPA decided to regulate greenhouse gas emissions from power plants. And the way the statute works is that once EPA made that decision to regulate new power plants, this provision 111D was triggered, and EPA was required to regulate existing power plants too. And the way EPA does that is the statute tells EPA to identify the best system of emissions reductions that's kind of like out there in the universe, to consider things like cost, to consider energy consequences, all of that, and then to set a top line number to reduce emissions. And at that point, EPA hands the baton over to states, which develop plans to implement that standard and to meet that standard. So what the Obama administration did in 2015 is it issued its regulation and said, the best system of emissions reductions, looking out over what the industry is actually doing, involves both improvements that the plant can make, by tacking something onto the plant or tweaking the plant's efficiency, but it also took into account that the way that plants were reducing their emissions is by shifting away from coal, for example, the most greenhouse gas intensive form, to natural gas or to completely renewable sources of energy. When the EPA issued that regulation, which basically, like I mentioned, told states to come back with plans by 2018 to meet those standards, the Supreme Court stepped in 2016 and stayed the regulation. This was the first time the court had ever stayed a regulation before any court had ruled on the merits of that regulation. So the Clean Power Plan never took effect. When the Trump administration came into office, it formally repealed the Clean Power Plan, saying that the EPA had interpreted the statute too broadly under the prior administration, put in place its own rule, which was incredibly narrow and basically only took into account the kind of minor efficiency improvements you could make, and then issued its regulation, which was immediately challenged. And states like West Virginia and the coal companies that are at the name of the case came in to defend, either to challenge the rule is going too far or to defend the rule. The DC Circuit struck down the Trump administration's action. And at that point, what that decision meant is that the Clean Power Plan kind of formally sprung back into existence, but because that was 2021, and so the states couldn't meet the deadlines of submitting plans by 2018, and all of the guidelines, the standard that EPA was asking states to figure out how to meet had already been met by the industry on its own without the need for any regulation at all. So at the time of that decision, there was no sort of regulatory action that had any impact on anyone in place. And yet the Supreme Court decided to agree to West Virginia's request to take the case and the coal companies on their side and to hear the case. And the reason why, I think, is because of how the court was being asked to decide the case. It was being asked to apply something called the major questions doctrine. And what that is in the normal course, when the court or any court is interpreting a statute, it usually starts with the text of the statute and tries to figure out what the words mean. Under the major questions doctrine, the court starts with a different question. It starts by asking whether the agency's action is major, which is defined in sort of a hazy way, but perhaps means that the agency is trying to do something new, trying to address a big problem in a way that it hasn't done before. Basically anything that kind of raises the hairs on the neck of a judge, asking if the agency is going too far, will trigger the major questions doctrine. And under that doctrine, when it's triggered, the result is that the court's going to look with skepticism on anything the agency does, and it's going to demand an incredible level of clarity from the statute. So instead of asking, does the statute authorize the agency to do this, it's going to ask, is there any reason for me to believe, or for me to kind of dislodge my belief that Congress didn't actually mean to give the agency this kind of power? So basically, it's a thumb on the scale against the agency that's going to be very hard to overcome. And you can see how groups that are skeptical of agency regulation or don't like it or are actively hostile towards federal agency regulations might like this doctrine, because it acts as others have said, a kind of one-way ratchet, where it really only applies when an agency tries to do something, but it doesn't help anybody who might want the agency to try and do something to protect the environment or to protect the public. So like I said, that's why people wanted the court to take the case, the kind of real motivation, and that's what they got. So the decision the Supreme Court issued this morning ruled against the EPA. It said that the Clean Power Plan, which again never went into effect, has no effect now. It said that what the EPA tried to do in that regulation went too far. It triggered the major questions doctrine, and the court wasn't convinced by any of the reasons why the statute was in fact clear. And I think, as the dissent points out, what's so notable about this ruling is that, you know, the majority opinion spends just a couple of pages talking about the text of the statute, and it really is not the same kind of discussion of statutory text that is in all of the other statutory interpretation opinions the court issued this term. It's not, what does the word system mean? It's, the word system is broad, and therefore it can't possibly be clear enough to authorize what the agency does, even if it might literally encompass, which the court kind of concedes, might literally encompass what the agency does, but because it's so expansive, it doesn't authorize it with the clarity that we would require. And that's just not the kind of textualism that the Supreme Court has proclaimed as the right way to approach statutes. And it's not the kind of textualism that's normally taught in law schools. And I think the dissent points out too that this is essentially a way for the court to look at a regulation, this court or any court, to look at a regulation that it doesn't like or thinks goes too far. That's essentially a policy judgment. And to say, we're going to make it very hard for the agency to win when its authority is challenged. In this particular case, if you take the words of the court, if you take the court at its word, all it did was say that the specific approach in the Clean Power Plan went too far. And a sort of ironic or odd result of the fact that it doesn't have any need to really engage with the text of the statute means that it doesn't otherwise limit what the EPA can do, because it doesn't have any reason to get into the weeds of what system means. So what the kind of bottom line climate impact of this decision is that the court has taken what is the most effective way to reduce emissions from the largest source of energy-related greenhouse gas emissions off the table. It has narrowed the scope of what the EPA can do, and it has given people that will bring the inevitable challenge to whatever the Biden administration does a pretty heavy tool to use when they bring that inevitable challenge. And we will see what the EPA does and how it grapples with this decision. So I don't mean to downplay the impacts of this decision, both as a matter of climate policy and as a matter of how to interpret statutes that protect the public, try to do something big to address big problems. This is a bad decision, but it's also a decision that doesn't go as far as people were concerned that it might. So for now, that is at least some comfort. As Tom mentioned, I'm also going to cover very briefly two cases dealing with religious rights. Just very briefly, the first case is called Carson, and this is a case about how Maine funds its public schools. Because of its geography, Maine localities couldn't, have a public school next to every student. It just didn't have the resources to accomplish that. And so the way the Maine statute works is that if a locality can't create a public school of its own, it can either pay for students to attend other nearby public or private schools, or it can pay for students to attend a school of the parent's choice, so long as that school is non-sectarian, meaning non-religious. And parents challenged that as a violation of their free exercise rights, and the court agreed with that claim. So what that means is that public funds will go directly to religious schools that teach children religion. And as Justice Breyer points out in the dissent, this is a sea change from a world in which states could choose to fund these kinds of school choice programs, but were not required by the Constitution to do so. And now it seems like they might be. The second decision on the religious rights sphere is called Kennedy. This is the case about the football coach that you might have heard of. And on the football coach's telling, he wanted to engage in quiet, private prayer on school property on school hours, but not in a way that would interfere with his job performance. And again, on his telling, he was fired, or at least not rehired, because he refused to stop doing that. And on that version of the facts, the majority says there is a free exercise violation and also a violation of his free speech rights. If you read the majority in the dissent, I think one thing that's incredibly striking about that decision is that they have incompatible versions of the record. The dissent points out that the football coach had a multi-year practice of kneeling at the 50-yard line, eventually surrounded by his students, reporters, politicians, and leading that group in prayer, and that is what he was asked to stop doing, not to pray in a more private, non-disruptive manner, and that on that basis, the school had done nothing wrong. Here too, there's another methodology point where the court, also refers to in both of these cases, also refers to tradition and history as well. So with that, I'll stop.
Thanks so much. The last topic that we want to cover is arbitration, which has been an area, obviously, in which the court's been very active in recent years. Deepak Gupta, who's a named partner in his own firm, and is probably the most successful consumer advocate at the Supreme Court, or at least of his generation. Deepak, do you want to talk about arbitration?
Yeah. Thanks, Tom, and thanks to the other panelists. It's been a great discussion, and I'm glad to be here with you. I wish we were in person. So yeah, the cases I'm going to talk about, these are not the big blockbusters of the term. These are probably not the cases that are going to make the headlines, like abortion, guns, religion, and the administrative state. But I do think I'm glad that Tom took some time out in the panel for us to talk about these, because these cases do concern the ability of ordinary consumers, workers, civil rights plaintiffs, antitrust plaintiffs to get in the courthouse door. These are cases, as Tom mentioned, under the Federal Arbitration Act, where the court is deciding whether companies can use clauses in the fine print of their contracts with consumers or workers to block access to the civil justice system. And the court has a steady diet of these cases almost every term, going back about a decade. Those cases have tended to break down along 5-4 lines. They've tended to be quite controversial. There's a case I argued over a decade ago called AT&T versus Concepcion, where the court decided 5-4 to allow companies to use the fine print of their contracts to prevent consumers and employees from banding together to go into class actions and to enforce arbitration clauses instead. So it used to be that these cases were principally 5-4, and the rule was kind of that the plaintiff would lose every single case. And I think that there is a shift that the court is that is underway at the court, where that's no longer the case. The 3 cases that I'm going to talk about very briefly, Saxon versus Southwest, Morgan versus Sundance, and Viking River versus Mariana. None of these were 5-4 cases. There was far more agreement across the whole court. 2 of them were completely unanimous, and one of them garnered pretty broad agreement. And the other thing that's notable is that in 2 of these 3 cases, the plaintiffs won, and they won in ways that I think will matter quite a bit going forward. All 3 of these cases involved plaintiffs who were workers, who were bringing wage and hour claims, sort of garden variety wage and hour claims. One of them was a sales rep for a cruise line, one was the cargo loader for an airline, and one was involved a group of Taco Bell workers. So the first case I'll mention is this case called Southwest Airlines versus Saxon, and full disclosure, our firm represented the plaintiffs in this case. My colleague Jennifer Bennett argued the case. And our client in the case was a ramp supervisor for Southwest Airlines, somebody who loads and unloads cargo onto the airplane. And the question is whether the Federal Arbitration Act applies at all to this, our client, Ms. Saxon. If you look at the text of the Federal Arbitration Act, which was enacted in 1925, it seems to exempt workers. Congress broadly exempted seamen, railroad workers, and any other class of workers. So if you look at that language, you might think that it just exempts any class of workers. But the Supreme Court, in a case called Circuit City, had interpreted that language much more narrowly to apply only to transportation workers. And so the question here was whether this airline worker would be a transportation worker, whether they're sufficiently like seamen and railroad workers that they would qualify. So that might seem like a pretty narrow question. It's just about transportation workers, but I think, as was the case with some of the cases discussed earlier, the methodological questions are at least as interesting here. The court departed quite a bit from the way it had decided the Circuit City case, and instead was very interested in, and this was our strategy in the case, in what the actual words meant in 1925. And it was abundantly clear from the historical evidence that people who loaded and unloaded cargoes would be considered workers engaged in interstate commerce. There's just an abundant amount of case law from that period. And so this is an example, I think, of a kind of progressive, original meaning kind of approach that advocates in these cases have been trying, and that has been working. And this has implications for workers in the gig economy, Uber drivers, people who are employed through apps, where this will decide whether they can bring class actions, whether wage and hour claims will be brought, and that's a subject of a lot of litigation. The second case I'll just briefly mention is a case called Morgan versus Sundance. And again, the question here might seem narrow, but the methodology is quite important and could have big implications. The narrow question presented in the case was whether, was basically what happens when somebody seems to have waived their right to enforce arbitration. Do you require that the plaintiff show prejudice? And lots of lower courts had required that. The Supreme Court said unanimously in a decision by Justice Kagan, we're not going to adopt that kind of rule that requires prejudice, the special arbitration rule. But the methodology that Justice Kagan managed to get all of the justices to sign on to is much more significant. It rejects the idea that this special policy favoring arbitration that had animated so many of the court's cases in this area, that policy is any kind of basis to allow what she calls special rules favoring arbitration. Instead, arbitration agreements are supposed to be treated just like any other contract, and are enforceable to the same extent, but not more so. This decision is going to be, I think, deployed in lots of litigation, because it represents quite a shift to say that the court, although it had adopted so many special rules favoring arbitration, is no longer going to tolerate that kind of policy-based justification. And then the final case that I'll just briefly mention is a case called Viking River Cruises versus Mariana. Now here the court seemed to stick to the more typical pattern from past cases. Justice Alito wrote an opinion concluding that California's Private Attorney General Act was preempted to the extent that it had special joinder rules that were inconsistent with the way the court understands bilateral arbitration. But the case was quite limited. It didn't go as far as employers might have wanted. And Justice Barrett wrote separately to say that the only reason this was preempted is that the Public Attorney General Act procedure that California had was similar to other aggregation devices that can't be imposed on parties through an agreement. So the court is sticking to the idea that arbitration cannot be used as a way of getting around, it can't be used to allow basically what looks like a class action. But I think the court is cleaning up its jurisprudence and is not going to allow broad policy-based appeals to arbitration going forward. And so surprisingly, the little guy notched some wins in the court this term in ways that may matter going forward.
Thanks so much, Deepak. Let's use the remaining time to cover some of the questions that have come in from the audience. And I think some of the most interesting ones involve stepping back from individual decisions and thinking about the court institutionally, the public's perception of the justices and the like. One of them is what do we think about confirmation hearings now? I think the general impression of them was pretty terrible going in. And there has been enormous criticism of some of the members of the court about what they said about the settled nature of Roe in light of the Dobbs decision. Does this change anything about confirmation, what we think, how we go about it, whether we pay any attention to it, whether we bother with it? Did anything go wrong here, unexpected here? What lessons did we learn, if any?
Justices or proposed justices are savvy. They have a good set of advisors. They will continue to take similar stances, and congressional leaders will continue to try to pry. But I'm not an optimist, but I'm a critical race scholar, so you wouldn't expect anything else from me.
I think we used to take their answers with a grain of salt, and now I think we're going to be taking them with a barrel.
I think if you go back and look at this, probably everyone's going to hate to hear this, but if you go back and look at what the justices said in their confirmation hearings, those were very carefully worded statements, and they were about the value of precedent, and there was no commitment not to take a certain action. Of course, they were designed to provide some comfort to people, but I don't think it's possible to say any of the statements that were made were inaccurate. And so, I think that kind of thing will continue to happen. It's very difficult for somebody as well prepared in a hearing to get any kind of commitment out of them. And in fact, it would be inappropriate for people to make commitments about what they may or may not decide.
The hearings are going to go forward because it's a chance for the senators to mug for the camera. So that's not a thing of the past where you just put the name on a piece of paper and the person gets confirmed. But I think allied with this is just the whole concept of stare decisis, right? If the court is willing to essentially jettison a 50-year settled precedent that is this salient, that is this popular, then what about like all the other decisions that no one's ever heard of, that lawyers really care about, but no one else is paying attention to? If they're willing to torch stare decisis for this, then I don't know what kind of horizontal stare decisis, what kind of control it has anymore at all. Maybe we're in the world where what Justice Thomas suggested in Gamble, where essentially everything's up for reevaluation under originalist principles, is the new order.
Can we talk about the leak for a second? What do you all make of it? What do you think it means for the institution? Are we going to see more of that? How does the court address it with the staff, with the justices, potentially with the justices' families? What does it do to the perception of the court? Do you think it was justified? This is a wild development in the history of the court that is antithetical to at least its own very, very settled practices and procedures.
So there have been leaks before. The Brethren is a whole book with lots of sourcing from clerks and.
No, but Deepak, let's be clear about the kind. Yeah. All right, we can stop using the word generically leak.
Yeah,
okay?
yeah. No, this is a
draft,
leak. Right.
Right, is a draft opinion overruling Roe versus Wade.
Yeah.
If you want to compare it to something that's happened, give me an example.
There is nothing that compares.
Okay.
It is a monster leak. All I mean to say is that there have been leaks before. So the idea that the confidentiality of the court was ironclad is not true. But this is just it fundamentally changes. I think things within the building. I think there's some evidence trickling out that it breeds a lot of distrust. And I think if it's true that nobody knows who did this, then people have to suspect anyone. I think that makes it difficult for the justices to work with each other and through their clerks. And so there's no question that it kind of casts a pall over not just this term, but the court's operations going forward. And I think there's some evidence just in the way, the opinions weren't coming out quite as quickly. There was a strange lull towards the end of the term that seemed like maybe there were some practical effects. I mean, I'm curious, Kirti, if you someone who was under those obligations and in that building not that long ago, I mean, can you imagine what would that have been like if you had been there?
Yeah, oh, sorry, go ahead.
Go ahead. No, go ahead.
Yeah, I was just gonna say, you know, when you work at the court, you get a speech from the chief that's really the sternest you can ever imagine him to be about confidentiality, and it is an incredibly strong norm at the court, if only because it's fraught enough without having to worry about these kinds of things. And I guess the only thing I'll say is that I guess two things. So one is I clerked before the pandemic when most people worked from their offices and we had laptops but weren't necessarily working from home. And so there's just a greater possibility that this, you know, the leak was, you know, maybe not intentional, or at least not, you know, not the result of someone setting out to do this, or and more of a, you know, leak of opportunity. But that's pure speculation, which I guess leads to the second thing, which is I do worry that the leak, as important as it is, overshadows the decision that was leaked and then turned into law.
Yeah, I think your second point was mine, which is I think the fact of the leak is so much less consequential than the content of the leak. And I think to the extent that anyone is questioning the Supreme Court, it's not the fact that an opinion got out, but the fact that it is willing to just remake the law in its own conservative image.
I think I might take a different take on it, because the norms and the processes are trans-substantive, right? So if you're willing to, again, leak on this, then what about lower courts? What about confidentiality, anywhere? And so, I'm institutionalist enough to know that, to think that, yes, it shouldn't distract from the fact that Dobbs is a major decision revoking a right that existed for 50 years. But if essentially the Supreme Court can no longer actually do its work, then it doesn't matter what the issue is. That affects the entire, term. If we end up with a scenario in the future where, only little, cliques of the Supreme Court are actually writing opinions and disclosing those reasons to others, that's a sort of a breakdown of a magnitude that we haven't seen before.
All right, let's end on that, and in a timely fashion, thanking both ACS for having organized this annual review, and thanking each of the panelists for having joined us, and all of our audience, both online and through C-SPAN, for joining us. We have a new justice on the court as of today. We have a huge number of challenges before the court next term, including related to affirmative action, today's grant on the independent state legislatures doctrine, which will have enormous effects on voting rights, major decisions related to the Voting Rights Act and access to justice. And so it's certain that we will be back here again next year, hopefully with somewhat better news, but no doubt with a court that has the same majority and probably the same aggressive posture. So thank you very much for joining us.